Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
The case for argument this afternoon, I just remember it, so it is. Museum of Art, Latin America versus Britain. Both sides ready.
Yes,
Yes,
sir.
sir.
Wanted to proceed.
Yes, sir.
May it please the court. My name is Jessica Kaziski, and I, along with Chris McKay, represent the petitioner, the Museum of Latin American Art. It is at this time the petitioner requests 3 minutes for rebuttal. In my co-counsel's time before the court, he will demonstrate that the affirmative defense of laches would bar Ms. Goodman's claim. In my time before the court, I will demonstrate that the 12th Circuit Court of Appeals should be reversed for 2 reasons. First, the language of the Immunity from Seizure Act would bar a suit for damages. Second, if the court interprets the statute to allow a suit for damages, it would decrease the amount of culturally significant items loaned to the United States, thereby limiting the American public's access to other cultures.
What language in the statute bars damages?
Your Honor, when Congress enacted the statute, it used very broad language. It said that no court of the United States may enforce any judicial process or enter any order, judgment, or decree that would have the purpose or effect of depriving the borrowing institution of custody or control of the cultural object.
And where do you find damages?
Your Honor, the term damages is not specifically stated in the statute. However, when Congress used the phrase to have the effect of depriving a borrowing institution of custody or control, this was very broad, and this would also encompass a suit for damages.
I thought this is a suit for conversion, correct?
Your Honor, Ms. Goodman is claiming for conversion and requesting that the fair market value, her alleged fair market value of $2.5 million be paid. She's not requesting that the painting be returned to her.
Right, but the traditional rule, I thought, in conversion was that when the defendant pays the judgment, the defendant has good title to the object. So there's no deprivation, no effect of taking the property away from it.
Yes, Your Honor, that is correct. However, the statute bars any judicial process that would have any effect, and this can
That's
have...
defined by custody and control.
Yes, Your Honor.
Custody and control has nothing to do with that.
No, Your Honor. However, the Sixth Circuit in In Re Bankers Trust stated that possession, custody, or control was physical possession or the legal right to obtain the property on demand. And the suit for damages can deprive the borrowing institution of custody or control in 2 ways. First, the Museum of Latin American Art may very well have to sell or deaccession the painting in order to satisfy the judgment. If the museum has to sell the painting in the middle of an exhibition and pull it from the exhibition, this would deprive the borrowing institution of custody or
How
control.
long does the custody remain with the museum under the present terms? Well,
Your Honor, the record is not clear how long the current temporary exhibition lasts. It's only noted that it is temporary.
temporary can be a long time.
Yes, Your Honor.
That's the only thing, it's just that abstraction of temporary.
Yes, Your Honor. The record does not indicate the length of time that the painting will be in the United States.
Isn't it our duty to determine congressional intent in the statute? We're not here to decide whether it was a smart statute or a foolish statute, but what it said.
Yes, Your
If
Honor.
Congress wished to easily have said any lawsuit or use the word damages. They certainly know how to do that.
Yes, Your Honor, and they did essentially mean to include any suit or attachment. The sponsor of the bill, Representative Rogers, in 1965 stated that the purpose of the bill was to ensure foreign lenders that if they lent their art to the United States, they would not be subject to suit or attachment.
Who are you quoting from?
Representative Rogers, Your Honor.
He was a sponsor of that.
He was one of the sponsors of the bill, Your Honor.
But we don't go to legislative debate until we decide that the statute's ambiguous.
Correct, Your Honor.
And just looking at the statute, where's the ambiguity?
Your Honor, there is no ambiguity. The effect of custody or control would include a suit for damages. It is a very broad phrase that Congress used, and it intended to be a broad immunity, a broad cloak of immunity for foreign institutions that lend their art to the United States.
You're saying there's no ambiguity, that it clearly applies to a suit for damages? Is that your argument?
Congress intended the statute to apply for a
I understand, but as Justice Wilson said, we don't get to congressional intent unless there's an ambiguity.
Correct.
So you're saying there is an ambiguity, or you're saying there's no ambiguity?
There is not an ambiguity, Your
It'll be the first congressional act ever passed.
Honor. That when Congress used the term effect of depriving the borrowing institution of custody or control, it has a very broad meaning and should be interpreted as such. The Immunity from Seizure Act, it has been relied upon over 1,500 times since its enactment in 1965. Foreign entities rely on this act when they are sending their artwork to the United States. When they apply for the Immunity Act, they do not expect to be subject to a suit for attachment or custody or control or damages. The protections that are afforded by the statute can tolerate no exceptions. And in interpreting the statute, as the 12th Circuit Court of Appeals did, creating limitations where they're intended there to be none would destroy it.
If we agreed with you on that, wouldn't we be rewarding the looters?
No, Your Honor. We would not be rewarding looters if the suit is interpreted to bar a suit for damages. The Immunity from Seizure Act applies as long as the immune object is in the United States for a temporary exhibition. If the painting was stolen, there may be other avenues that a litigant can pursue to assert their rights. They just can't do it when the painting is in the United States under temporary exhibition under the Immunity from Seizure Act. This brings me to my second point. The 12th Circuit Court of Appeals should be reversed because interpreting the statute to allow a suit for damages would decrease the amount of culturally significant items on loan to the United States, thereby limiting the American...
We don't get to your second point if we were to decide that the statute simply doesn't cover down.
Correct, Your Honor. However, the broad language used in the statute indicates that it was intended to be
I understand.
very... Interpreting the statute to allow a suit for damages would decrease the amount of culturally significant items loaned to the United States and limit the American public's access to other cultures. In response to the Portrait of Wally litigation, whereby...
Wouldn't it just put a greater burden on art collectors and people like the museum to trace back the source of the art that they're collecting? I mean, it just puts more burden on them.
Your Honor, in applying for a grant of immunity, the borrowing institution must first certify that the object is of cultural significance and in the national interest, and that the borrowing institution must certify that it has done a provenance search and researched the object and certifies that there's no claims, that it does not see any claims to that object. So there's already done one round of provenance research if the grant of immunity has been issued.
But there's certainly, and you probably know more about this than we do, but there's certainly further background checks that a collector or a museum can do. They're not beyond what's required under the statute.
Correct, Your Honor. However, if we require museums to continually research the provenance in excess of what is even required by the Department of State, museums simply will not be inclined to loan their art to the United States. It would be too
This
much.
museum didn't do anything.
No, Your Honor.
So why do you talk about policies where they're doing it? They made no effort whatever to find out the provenance of the stuff.
The lending institution did not. However, the DePaul Museum of Modern Art, as a prerequisite to being granted immunity, would have had to search the provenance of the piece to determine that there were no outstanding claims. If we require lending museums and borrowing institutions to even further research the provenance, which is a very expensive process, museums will simply not be willing to undergo the expense and the time to borrow from to send their art to the United States, nor will the United States be willing to undertake that expense to borrow art from other countries.
How do you know that?
Your Honor, the American Association of Museum Directors even noted that research of provenance can be very expensive, it can be very time-consuming, and it can involve access to documents and records that are simply not available. If we require such a high burden for a lending institution or a borrowing institution, they would not be willing to undertake such a burden and then still possibly be subjected to a crippling damage award.
The United States museums and places are loaned to foreign countries.
I'm sorry, Your Honor,
The
for your
United
question.
States loans objects to art to various places throughout the world.
Yes, Your Honor.
Do you know whether other nations afford the same security that you're thinking of?
Your,
Should apply here or something like that?
Your
As
Honor,
we set it out, we do it on our hope that they will return, that we will seize it.
Your Honor, I'm not familiar with the foreign law around U.S. sending its art to another country, or I would assume that there would be some sort of protection required as well.
It seemed to me the argument for reciprocity.
Yes, Your Honor. In the Portrait of Wally litigation, when the Manhattan Museum of Modern Art, when the Manhattan District Attorney issued a subpoena for the Metropolitan Museum of Art to produce the painting, the New York Court of Appeals squashed the subpoena. And in response to that decision, the director of the Museum of Modern Art, Lynn Lowry, noted that the decision to squash the subpoena was a victory for New York, and it gave assurances to foreign lenders that if they did indeed send their art to the United States, that they would not be subject to such suit. He also noted that specifically because of the litigation that had started during Portrait of Wally, a previously promised collection that should have been sent to the Museum of Modern Art was withdrawn, specifically for fear of suit. And indeed, in Malevich versus City of Amsterdam, the district DC court held that had the artwork been in the United States, no court could have or would have entered a judgment that would have deprived custody or control. The City of Amsterdam specifically stated in that case that had it known it would have been subject to a suit in the United States, it would not have sent its art over.
That's what they said after that.
They said, well, during the litigation, Your Honor, yes, they noted that had they known that they would be subject to this suit, they simply would not have sent their art.
Why isn't everything that you're telling us a perfectly good argument to make to the appropriate committees of Congress to amend the law and fill in this gap?
Your Honor, it is the museum's position that the law does not need to be amended. It is broad. It says that it has the purpose or effect of depriving the borrowing institution of custody or control.
If this case were to go to trial,
Yes, Your Honor.
there would be a jury trial for conversion?
Yes, Your Honor.
Okay. And can you imagine that trial going forward without the painting in the courtroom as it exists?
I'm not sure, Your Honor. Maybe it could, maybe it couldn't.
I thought your position would have to be that it must go forward without the painting.
Well, it would have to be that it would have to go forward. There's no way that the court can deprive the borrowing institution of custody or control. So it would not be able to. However,
Just discovered shortcomings of the Supreme Court of the United States. Can't fix that. Then ask what you don't get.
Well, they can take a picture.
Your Honor, I see my time is up. You'll briefly answer the question. I suppose, yes, Your Honor, if they did absolutely need to have the painting in the courtroom, we could take a picture of it. However, in order to determine the very value of the painting, which Ms. Goodman is asking, an appraisal would have to be done, which would also require the museum to make the painting available. And it is
Under court order. Under court order.
Yes, Your Honor. And it is for these reasons that the petitioner requests that the 12th Circuit Court of Appeals be reversed and judgment rendered in favor of the museum.
Thank you, Counsel. I think we're going to hear from the other petitioners. I think that's how they do it here. In this particular.
May it please the Court. My name is Chris McKinney, and I also represent the petitioner, the Museum of Latin American Art. During my co-counsel's time before the Court, she explained why the Immunity from Procedure Act bars Ms. Goodman's claim for damages. During my time before the Court, I will explain why the 12th Circuit erred in granting summary judgment to Ms. Goodman in this case. Now, the 12th Circuit's ruling was improper for two reasons. Those go along the doctrine of latches. So first, Ms. Goodman did not exercise due diligence in asserting her claim, and her delay was inexcusable. Second,
What difference would it make? The museum didn't do anything to find out it was stolen either.
you're right.
They're not be just.
You're right, Your Honor. And the only time the museum did a search, which relates to the prejudice argument in the second prong of latches, was whenever the Napoleon Museum of Modern Art actually conducted a provident search. And the second prong of latches goes to the prejudice established by the museum. And that is shown from an evidentiary standpoint as well as an economic standpoint. And because the lower court only looked to the causation element within the prejudice, they ignored other facts that led to prejudice from an economic standpoint and evidentiary standpoint.
What do you mean?
Well, Your Honor, whenever the 12th Circuit granted summary judgment to Ms. Goodman in this case, their only focus in that case was looking to the causation between the delay of Ms. Goodman bringing her claim and the prejudice established by the museum. So they only looked to that one fact while ignoring an enormous wealth of facts that point to a genuine issue of material facts regarding economic prejudice and the evidentiary prejudice.
Okay, so you're not saying you have evidence of economic prejudice or evidentiary prejudice, just that there's a question of fact as to whether there is prejudice?
Yes, Your Honor, and that's all that it is. It's a question of fact to defeat summary judgment.
Okay, so what is the potential prejudice? What specifically are you referring to in terms of prejudice?
Well, Your Honor, it's not even potential prejudice, it's real prejudice.
Okay, what is it?
And the petitioner, or the respondent, will most likely claim that we're only doing a frenzied brandishing of a cardboard sword, but the economic damage that the museum has established in this case is that they've been taking care of this painting since they received it, and they have allowed it to be viewed in other countries like the United States. They've cared for it. Otherwise, this painting might have been out on the street. And it's through all these investments that the museum has made that they would be economically prejudiced. Now, if we look at the case of Pro Football versus Harjo, Your Honor, we see that 6 Native American plaintiffs brought suit in the district court for the District of Columbia against the Washington Redskins. And in that case, it was a trademark infringement. And those plaintiffs delayed in bringing their claim for some time. Now, the Redskins have already invested millions of dollars into the Washington Redskins brand, and the court found that it prejudiced the Washington Redskins, and that the prejudice element of latches did apply in that case.
You're comparing that to just taking care of the painting?
Yes, Your Honor. The painting's worth $2.5 million. So from the point that the painting was lost in 1950 till 2010, the painting has been gaining notoriety, it's been gaining value. And to allow Ms. Goodman to piggyback off of what the museum has invested into this display and the care and the traveling of the painting.
Yeah, but in the Washington Redskins case, nobody stole an image.
Correct.
The rule you're arguing for here sounds like the longer the thief takes care of the property, the greater the right becomes.
It's certainly, Your Honor, from an investment standpoint. However, you have to look at the diligence and whether the painting was actually.
The theory is though that you've invested in stolen property. We have to take that for granted. Assume the plaintiff can prove her case in order to even get to the affirmative defense, right?
Your Honor, the record reflects that the painting was allegedly stolen. We don't know the underlying facts and circumstances that
Right,
were
but for purposes of your latches argument, it's an affirmative defense. We assume the plaintiff can prove everything she alleged,
Yes, Your Honor.
including that it's stolen. And you're arguing for prejudice based on your care and custody, your protection of the painting. It seems to God to me.
Well, Your Honor, the economic prejudice is only one part of the prejudice prong of latches. The other prong is evidentiary prejudice, which is established whenever there's a loss of record, there's a loss of witness, or the court's reliance on memories of past fated events.
What witness were you deprived of?
Your Honor, we were deprived of multiple witnesses in this case. First, we were deprived of Zoe Solar, which was the creator of the painting of Las Casas and Los Cerros. Now, Mr. Solar would have told us the exact transaction between him and Ms. Komarova, that the respondent's claim is the original owner of the painting. However, we don't know the underlying circumstances of that transaction, whether it was a loan, whether it was...
You're not contesting the fact that this was a stolen painting.
Your Honor, I can only go by what the record says, and that it was allegedly stolen. So, and all of these facts that we're bringing here today isn't just mere speculation. These witnesses would have told us the transactional circumstances. They would have told us who actually owned the painting, whether, principles like lex situs or market uve actually apply in this case.
This is all speculation.
Your Honor,
There's
it's
a
not...
single fact to support that.
In cases like these, it's okay to, I wouldn't use the word speculate, Your Honor. These witnesses, yes, Your Honor, exactly, reasonable inferences.
Latches is an equitable defense.
Yes, Your Honor.
So we have to also look to the fairness of the crime.
Yes, Your Honor.
Is it fair to deprive the legitimate owner of money damages for this loss of the stolen work all these years?
In a latches analysis, yes, Your Honor, because the plaintiff can't sit on her hands. She can't sit on her rights. And latches prevents this court from entertaining a claim by someone who hasn't done anything since 1950 in asserting her rights. And if we look back until 1950 and we look at the diligence,
She's supposed to do.
well, Your Honor, there were a number of things that Ms. Komarova, Ms. Frida Goodman, and Ms. Amy Goodman could have done to ascertain the whereabouts of the painting, or to look at a catalog raisonné of Zoe Solar's works, or even make a claim with some type of government agency that records and collects claims for stolen artwork.
But doesn't your prejudice have to stem from her failure to do that, and the fact that the person you acquired for the painting from didn't look at any of those things means that your prejudice is not causally tied in any way to what she and her predecessors failed to do, right?
And that's only one element of the prejudice prong. However, we successfully pled that prejudice existed from that evidentiary standpoint and from that economic standpoint. And it isn't just because we didn't do a search. We can see the fact that we didn't do a search into the provenance of the painting. However, was it reasonable for Mr. Moreno to do a provenance search at that time? And then subsequently, would it be reasonable for someone who receives as a gift that makes the entire collection of the Museum of Latin American Art to do a provenance search on all the paintings that Mr. Moreno had in his collection? As my co-counsel stated, to do so would be an expensive and tedious and arduous process that wouldn't allow a nonprofit museum to even survive and do what they're supposed to do in their works. further, Ms. Goodman hasn't done anything, she and her predecessors haven't done anything for the past 60 years in trying to find out where the painting was.
Let me ask you about a different angle here, because I know it's not this case, but we need to worry about this possibly. Is the owner of stolen property required, under your theory, to sound the alarm officially and publicly? Or does the owner also have an alternative to say, look, I don't want to alert the market and potential scoundrels out there that we're looking for this until I find it. So maybe I'll hire a private detective. But the last thing I want to do is sound an alarm that will send a disreputable, dishonest possessor, buyer of this property, to hide it underground.
Your Honor, to say that paintings, stolen works at all, would go underground if they were searched for, really can't be used in this case, because courts always have established the fact, or established the premise, that due diligence in looking for stolen objects, such as paintings, we are really looking at that due diligence by the plaintiff in this case. Now, yes, Your Honor, there are certain circumstances where someone should just keep their eyes and ears open if they're looking for something that's stolen, but that's only in the context of whenever it's someone from within. Like, say, there was a museum whose workers were actually helping in stealing paintings. Now, to adopt...
So the rule depends on who the thief was?
Your Honor, the rule depends on the facts and circumstances of every case. And in this case, Your Honor, Ms. Goodman had ample opportunity to look in catalog resumes, which were published, to look at the, in 2007, January 2007, she had an opportunity whenever Zolsolar's collection was being publicized in the DePaulian newspapers and all across the news media there. However, she didn't act on her claim there. She waited until 10 days after.
And what if she did look? What would she see?
She would have seen that the painting, Las Casas and Los Cerros, was coming to DePaulian, and she would have known exactly at that point who was in possession of her painting. And that would have allowed her to bring this claim sooner and wipe out any prejudice that the museum has established here today.
Sooner, you mean in 2007?
Yes, Your Honor.
Well, does that make any big difference between 2007 and when she actually brought this?
Certainly, Your Honor. Certainly, Your Honor, in terms of looking at the diligence of the person who's claiming ownership to the painting, in this case, Ms. Goodman. Now, she waited until 10 days after the painting was on display in DePaulian. And we look at the case of Greek Orthodox Patriarchate, and we see that the plaintiff in that case waited until just 7 days before the Greek manuscript written by Archimedes, a 10th century manuscript, was going to be put up to auction. Now, he retained counsel and obstructed the sale of that. Now, the court in that case said that at any time previous to that point, he could have retained counsel and helped do a search for that painting, for that manuscript. In the Sanchez court, Sanchez versus the trustees of the University of Pennsylvania said, in their opinion, how much education, how much money, or what going into how much effort does it take to look into the relevant literature, or even ask a public librarian where to search for information about this. And Your Honor, Ms. Goodman hasn't done a single thing for the past 60 years. Ms. Komarova, Ms. Frida Goodman, or Ms. Katie
There
Goodman.
wasn't much of a position. I think it's the early part of the 60 years. Like, I think 60 years seems longer to you than it does to me. The conditions of World War II have something to do with it.
Your Honor, I see my time is up. May I briefly answer your question?
I would not.
May it please the court. My name is Caitlin Jones, and I represent the respondent, Amy Goodman. I will show that the Immunity from Seizure Act does not bar Ms. Goodman's suit for damages, and my co-counsel, Stephen Gardner, will show that the defense of laches does not apply. Your Honors, petitioner is asking this court to upset the balance Congress struck in 1965. This court should uphold Congress's intent and affirm the decision below for two reasons. First, the 12th Circuit properly followed the ordinary meaning of the Act and previous interpretations of the text. Second, public policy...
As I understand your opponent's argument, if we did say damages would apply, in effect, care and custody would mean it, because it's tied in with the suit for damages.
No, Your Honor, I respectfully disagree. The effect clause cannot be read outside the context of the entire immunity from seizure statute. The effect clause would get at an action such as an injunctive order. An injunction is defined by Black's Law Dictionary as a court order commanding or preventing an action when there's no other remedy at law. Here, as the record on page 4 reflects, Ms. Goodman seeks a remedy at law, $2.5 million, the fair market value of the painting. Turning to my first point. This court has stated that the most trustworthy form of statutory interpretation is to follow the ordinary meaning of the text. And that's exactly what the 12th Circuit did. They followed this court's advice in Connecticut National Bank versus Germain. The title of this act is also useful in reducing ambiguity.
What does having the effect, the words having the effect in the statute mean, in your view? If they don't mean a suit that in effect keeps the person from retaining ownership of the property. What does having the effect mean?
Your Honor, having the effect when read in conjunction with custody and control is a very physical idea. It gets to a basic property law of replevin. Replevin and conversion are the two types of remedies available, or two types of actions available for a victim of theft. An action in replevin, if Ms. Goodman was seeking one, she'd be seeking a remedy of the actual painting of Casas to be returned to her. However, that's not what Ms. Goodman is seeking. She's seeking an action in conversion, as the record on page 4 reflects. She's looking for money damages, damages which are fungible, damages which are wholly divorced from the actual physical painting of Casas.
Don't you think Congress was intending to encourage the use of art this way, sending it over to place, distributing it so that more people can see it? And if we accepted your interpretation of the statute, that would be contrary to that policy.
Yes and no, Your Honor. I absolutely agree that Congress's purpose was to facilitate cultural exchange and to allow the display of artwork. However, Congress has not seen any type of chilling effect. By the petitioner's own admission, there have been 1,500 pieces of art covered under the Immunity from Seizure Act since 1981, and 447 of them have come into this country under the protection of the Immunity from Seizure Act between 2000 and 2007.
Why would Congress distinguish between actions for replevin and actions for conversion? Why would they make that distinction?
Your Honor, an action in replevin would deprive the world, no, not just Malva, of seeing a painting like Casas. Congress balanced this and said they would protect the physical piece of art.
They're famous for being art suppliers.
Do you have any support for that other than your reading of the text of the statute?
Yes, Your Honor. The petitioner has relied upon a single statement by Representative Rogers from the state of California, who is the proponent of the bill. However, as Justice Scalia noted in Conroy v. Aniscoff, this is a country of laws not governed by the intentions of legislators, especially not a single legislator. Furthermore, there's a House and Senate report, House Report number 1070 and Senate Report number 747, that are both inconsistent with Representative Rogers' statement. Both of the reports say that the Immunity from Seizure Act is a process to render a piece of art or cultural object immune from process of seizure or attachment. These are very physical ideas. Congress wanted to protect a unique piece of art like Casas and not worry about a damage which Ms. Goodman is seeking, simply in money. Damages which are fungible, And how Malva chooses to spread that cost, whether they hire fewer workers, they charge more for exhibits, is not within this court's purview.
Can you prove your case at trial without, for example, having an expert examine the painting very closely?
Absolutely, Your Honor. If there was
So
a
you
praise,
can prove that it's the authentic.
yes, Your Honor. And this court could follow the lower court's decision in Magnus versus the Russian Federation, when it held that any piece of artwork under the protections of the Immunity from Seizure Act is not subject to a temporary restraining order, a writ of attachment, a writ of execution, or any type of injunction. However, the effect of the clause, as Your Honor noted earlier, could be invoked if, say, the court ordered an injunction, and to Your Honor's concern, the painting was necessary at trial. That would be the effect of language that Congress was concerned about.
But how do you prove that it's even the authentic if it's the same object that your client's grandmother received from the artist without expert testimony that would require physical inspection over the objections of the museum and therefore subject to a court order?
Your Honor, maybe the painting would be necessary in the future for some type of appraisal. However, what Congress wrote is what Congress meant. And this court in Hewitt versus Mertens Associates said that Congress says what it means and means what it says. Congress balanced these concerns in 1965. They balanced the concern of showing a piece of art with the concern of an American citizen.
That doesn't respond to Justice Hamilton's point. If the painting is necessary to be held somewhere, or appraisals, which aren't done overnight, isn't that in effect custody and control being taken? And so violating the statute.
Yes, Your Honor. That would violate the statute because Congress intended for it to cover physical seizure as well as a type of injunction. But it would not necessarily need to happen if this court followed the example in Magnus versus the Russian Federation. Furthermore, Your Honors, this statute has not been amended since 1965. And per this court's advice in North Haven Board of Education versus Bell, the acquiescence rule infers legislative approval from a failure to override judicial interpretation. There have been two decisions that are published concerning the meaning of the Immunity from Seizure Act. The first is Magnus versus the Russian Federation, and the second is Malowitz versus the City of Amsterdam. Petitioner has told you that the Malowitz decision bars a suit for damages. However, what happened in that case is that the money damages suit was allowed to proceed. It finally settled, but that did not at all influence what the court said about the Immunity from Seizure Act. Petitioner told you that the Malowitz court said the Immunity from Seizure Act prevents any deprivation of custody and control. However, the following sentence of that opinion on page 311 of that opinion says they're talking about physical custody. Again, seizure, just like the title says. The title of this act is immunity from seizure, not immunity from damages, not immunity from all lawsuits.
Counsel, it sounds like you're wanting us to infer legislative acquiescence from two interlocutory lower court opinions. Is that right?
Yes, Your Honor. The Magnus decision.
Doesn't that suggest that Congress pays a lot closer attention to page 333 of whatever report it was than most of us do?
Potentially, Your Honor, but the Magnus decision rendered a $234 million loss damages suit. And if, as the petitioner suggests, there would be some type of chilling effect, a $234 million damage suit against the Russian Federation might have caught Congress's attention. Finally, Your Honor, the Immunity from Seizure Act is in derogation of the common law. This court in Norfolk Redevelopment versus Chesapeake and Potomac Telephone Company advised that when Congress writes a statute in derogation of the common law, it should be construed narrowly. And that's what happened here. Common law allows for inaction in replevin or conversion to a victim of theft. By its own words, Congress cut off the action for replevin, allowing only a suit like Ms. Goodman's, a conversion action, to proceed, therefore derogating the common law. And this court should follow its own advice in the Norfolk Redevelopment case and construe this statute narrowly. Turning to my second point. Public policy supports allowing Ms. Goodman's suit to proceed. Your Honors, principles of general fairness are at issue today. The petitioner's reading of the statute.
We're dealing with a bona fide purchaser. Museum's a bona fide purchaser. Nobody says a museum is stolen.
Correct, Your Honor.
Why would it be fair to deprive the museum of its rights?
Your Honor, Congress wrote the statute in 1965, and what they did was balance the interest of a foreign sovereign with those of an American citizen. Petitioner's reading of the statute would have you believe that Congress placed the interests of foreign sovereigns above those of an American citizen like Ms. Goodman.
It's not just the interest of foreign sovereigns, it's the interest of art, it's the interest of sharing art. There's lots of interests at stake, not just, as Justice Wilson pointed out, a bona fide purchaser, but also everybody who wants to go and see this work of art, correct?
Absolutely, Your Honor. But that same goal and that same vision of showing and experiencing cultural objects is still met and maintained by this reading of the statute. Congress has allowed a suit for money damages while still not touching the unique piece of art. Casas could remain on display, but Ms. Goodman's suit could proceed, and the two are wholly divorced from one another, unless in the case of an injunction, as your co-justice noted earlier. Furthermore, Your Honor, the petitioner has pointed to no chilling effect since the enactment of the statute in 1965. In fact, the petitioner announced 1,500 applications were successful in the United States since 1981, and 447 of them in the last decade. This does not suggest a chilling effect. Further, the two cases that are published, Malowitz and Magnus, both would have caught Congress's attention. A $234 million lawsuit against the Russian Federation that was successful should have caught Congress's attention.
But they got Russia's attention too.
Yes, Your Honor. However, Congress again chose not to act. They chose to stand by the words originally written in 1965 that this was a physical seizure and any type of injunction that they were trying to prevent. They were hoping to keep the art completely intact while allowing an American citizen like Ms. Goodman to proceed with her claim for a very valuable asset.
If your client couldn't proceed here, she could still proceed somewhere else, right? Even if she were completely barred from slave here, she could proceed in the country where the art actually lives, could she not?
She could, Your Honor. However, the courts in Argentina are not as hospitable as the courts of the United States because Argentina follows the European Union's vision of favoring, their common law favoring a good faith purchaser rather than the American common law which favors the victim of a theft, and that good title cannot pass through theft.
Otherwise, the British Museum would have to return 3/4 of that.
Yes, Your Honor. And additionally, to Your Honor's concern, a lawsuit in Argentina would be extremely difficult for Ms. Goodman to proceed on. Argentina requires 3% of the amount demanded up front, so Ms. Goodman would have to pay $75,000 up front. And beyond that...
Isn't that pretty reasonable? Most of Europe thinks that we're way too litigious. And it's too easy to get in. What's there you say? There's something uncivilized about the European and Argentinian rules?
No, Your Honor. However, forcing Ms. Goodman to proceed with her suit outside of the United States is contrary to what Congress intended. Congress intended for a citizen like Ms. Goodman to be able to proceed on an action in conversion for fungible money damages that would not at all affect the petitioner's use and control of the painting Casas.
My question to your opposing counsel, I said, well, Congress knows how to put in damages if it wants to. But let me ask the other side of that coin to you. If Congress did not want damage suits, it could easily have said something.
Yes, Your Honor. However, Congress focused on using the physical words of custody and control to effectuate its use, and furthermore, Title the Act, Immunity from Seizure Act, to again reinforce this physical idea. The word damages is not at all in the statute. And by this court's advice in Dean versus the United States, this court should resist reading words into the statute that do not appear on its face. This court should affirm. Thank you.
Thank you.
May it please the court. My name is Stephen Gardner, and I also represent Amy Goodman, the respondent. Under the common law, a purchaser cannot obtain good title to property if there is a theft at any point in the chain of custody. The defense of laches is only available when a defendant has proven that there was an unreasonable delay that was the direct cause of prejudice. This court should hold that the
We're going to say that 60 years was a reasonable delay?
Yes, Your Honor. This court should hold that it is a reasonable delay because an unreasonable delay is defined as unexplained and inexcused. And this court should hold that the defense of laches does not bar Ms. Goodman's claim for also, not only is it not an unreasonable delay, but second, Mal is unable to point to any direct cause to any prejudice. Turning to my first point, an unexplained or unexcused delay is the only time that the delay will be unreasonable. However, page 2 of the record, it shows this court that Ms. Komarova fled Austria in 1938, placing her belongings into a warehouse. She did not learn until 12 years later that that warehouse was empty, and most likely the contents had been stolen. However, she had no indication of who stole them. Austria during
But
World
she
War
never made any report to anybody about that.
That's correct, Your Honor.
How can that be true?
Your Honor, at that time that she discovered the painting, she had no indication of who had actually taken it.
All she didn't have to know who took it. All she had to know was that it was taken and announced to the world that my painting's been stolen. That's a simple thing to do.
No, Your Honor. As courts draw a difference between institutional claimants, art collectors as claimants, and an average claimant, as Ms. Komarova and her daughter and granddaughter were average claimants, they were not plugged into the art community. In Arazi versus Rizik, the court drew a distinct difference between those with access to the channels of the art world, those with the knowledge necessary to track down these paintings. And in that case, a lesser burden is placed on those that do not understand the channels available to them.
Okay, so she made mistakes, fine, but she did nothing, right? It's not like she went to the wrong place or registered to the wrong registry. She did nothing. And she and her mother and her grandmother did nothing, right? And between 1980 and 2001, it was exhibited 7 times.
Yes, Your Honor, it was exhibited. However, it was exhibited in Latin America. And it was any literature with it was in Spanish.
Sure, but it's an Argentinian artist, right?
Yes, Your Honor.
So why is that any surprise?
Your Honor, the painting went missing in Austria, and Ms. Komarova didn't discover that it was missing until she was in New York City, an ocean away. A non-institutional claimant, or one without the knowledge of the art world, would not reasonably suspect that an artwork would find its way back to Latin America.
It wouldn't move around as much as she had.
Well, no, Your Honor, as she deliberately left for America fleeing persecution. And
Is it your position that it's not even a factual issue as to whether there was any due diligence here?
no, Your Honor, as the petitioner is calling for latches to completely bar any claim being brought. However, if there are factual issues, the defense of latches should not bar any claim, especially on summary judgment. And those issues could be hashed out at trial. However, the defense of latches does not allow, or the defense has not proven the defense of latches, as it is their burden to show them that the defense of latches is a complete bar to a claim.
But wait, you were granted summary judgment, so they were deprived of any evidence that they might want to put on trial, right? You were granted summary judgment by the district court.
Yes, Your Honor. So the defense of latches, in requiring this unreasonable delay, does take into account the equities of all parties, and it should take into account the position of all parties. Mala itself, as an institutional claimant, an institutional defendant, is placed at a greater advantage than Ms. Goodman as a non-institutional claimant. She asserted her.
In theory, I agree with that, but since you all there wasn't anything for them to fund, right?
Yes, Your Honor. However, as petitioner stated, Moreno purchased this this painting. Moreno himself, as an art collector, has a duty to abide by the standards of the art community. And art community requires a search on title at the purchase of artwork.
Well, if he did search, what would he find?
Your Honor, there's no exception to a search rule, a hindsight exception to the search. It still must be taken, which takes me to my second point. Even if there is an unreasonable delay, there are two prongs to the laches defense. It requires that there be a showing of prejudice, and that prejudice be a direct result. As this court stated in Rule Airborne Instruments versus Windbeer, there must be a causal connection between the delay and the diligence. Without that but-for connection, petitioner is unable to show that the defense of laches succeeds. And as the record clearly reflects, not only did Mr. Moreno not do a title search on this painting, Malva did absolutely no title search on this painting. This painting was sold at a flea market in 1948, 3 years after the war in Europe ended. An institutional buyer should have recognized this red flag as their chance to do a title search. However, they took absolutely no steps. It is the requirement set forth by the industry standards. This requirement has been studied in the 1958 Hague Convention, attended by over 46 different countries. The 1998 Washington Conference was attended by over 40 countries, including Argentina. And in 2007, Argentina and the United States were both signatories to the Terezin Doctrine, which all addressed the extreme circumstances that those fleeing persecution are put under and the inability for them to recover these artworks and these institutions' duty to return these artworks to the rightful owners. In Greek Autosophilis Church of Cyprus versus Golden and Feynman, the court noticed this burden placed on institutional defendants. And they stated that if there is suspicion around the title of a painting, or in that case it was a mosaic, it is the duty to do a search. And without asserting that duty, there is no but-for cause to the prejudice and to the unreasonable delay.
So it's your position that the prejudice has to be directly tied into the lack of diligence on the part of your client?
Absolutely, Your Honor. And not only does the prejudice have to be tied in, there must be prejudice present. The petitioner points to suggestions that perhaps there is prejudice within the record by the absence of witnesses. However, in the Worth versus Ballinger, the Second Circuit clearly stated that you cannot suspect prejudice. It must be clearly shown. It must be clearly proven that there will be prejudice.
How do you do that without, if what you've got is missing witnesses? If you've got, for example, the defendant here could raise questions about the terms of the original transaction. Was it a gift? Was it a loan?
Exactly, Your Honor. The petitioner is unable to say what testimony would be available.
Why isn't that prejudice, 60 some odd years after the fact?
Your Honor, it's not prejudice because the petitioner is unable to directly state what testimony is necessary. They're only able to speculate about what testimony may come up at trial. However, it must be clearly stated that there is prejudice. And there's also
Let's think about trial. How does that work? How does your client prove ownership?
Your Honor, my client
Other than through hearsay.
My client proves ownership as the record stands. It is uncontested. The petitioner has not contested any of the facts within the record.
And I misspoke because actually they were granted summary judgment. Am I correct in the trial court? The trial court granted summary judgment to the defendant.
Yes,
correct. So what evidence do you think you could have put on theoretically at trial to rebut a laches defense?
I'd like to answer that in 2 points, Your Honor. First, the laches defense places the burden entirely on the defendant to prove both prongs. However, second, to prove or to even bring about a laches defense, you must have good faith ownership of the painting. The only way that an institutional defendant or an institutional buyer can get a good faith ownership of artwork is by doing their diligent search, as the commercial standards ask for, and was noted in Moorgold versus Keeler in the Seventh Circuit, that it's the standards of the art community for these purchasers to do a title search, especially when there's suspect circumstances surrounding the ownership. As the record clearly states, not only was this painting purchased in 1948 in Vienna at a flea market, there's also a gap from 1938 until the painting was purchased in 1948, indicating that this painting has been misplaced, has been lost, or has been stolen. And there are many red flags that Mr. Moreno should have recognized, and especially Navas as an institution with the resources that they have. And in fact, in 1968, the International Foundation for Art Research was created. And at the time that it was created, it cost $25 to do an entire title search. The nonprofit organization would take it upon themselves to do that search for anyone that applied.
What would they have found if they didn't?
Your Honor, it's likely that they wouldn't have found anything, as it was not reported stolen. However, the burden that is put on these institutions and these burdens on institutional buyers do not have a hindsight exemption that states that the search is only good if it turns up any results. It's still a requirement by these purchasers. It's still a requirement by these institutions. Without being able to prove good faith ownership, Your Honor, going back to your question, the defensive latches would not be available at trial, and that would be necessary for our testimony. And
Why isn't the cost of litigation direct prejudice? It's been a long, hard trail that this case has followed. High-priced lawyers such as yourselves come to the Supreme Court. Why isn't that part of their prejudice?
Your Honor, it cannot be taken into account for prejudice when Ms. Goodman is simply trying to get what is rightfully due to her. Over 60 years have gone by without...
And that's not my question. I'm talking about the cost of litigation to the defendants.
Your
Why
Honor,
isn't that prejudice?
No, Your Honor, the cost is a byproduct of not taking their diligence and not taking the title search on this painting. And in fact, the American Association of Museum Directors has a policy that is echoed throughout Europe and Latin America and followed after this 1998 Washington Conference on the returning of Nazi-looted artwork that states that when paintings have been found to come from this era, World War II era, from Europe, that they're required to do some type of look into the ownership of that painting. And if they find any suspicious circumstances around that painting, it should be placed on their website to put the community as a whole on notice. And the failure to do so is what the defendant has exposed themselves to, so that cost will expose them as a natural byproduct of a failure to take that search. And Justice Hamilton, I'd like to address a question that you asked Petitioner. You asked if there was an effect of paintings going into hiding once a search was taking place. And Petitioner stated that there wasn't. However, in Solomon R. Guggenheim versus Lobel, the court recognized that when a search takes place and the art community is put on notice about a search, that paintings often do go into hiding. And it's often more difficult to find those paintings.
That would be a stronger argument if your clients had actually thought of it.
Yes, Your Honor. Yes, Your
They
Honor.
didn't do anything.
Yes, Your Honor.
Tough to overcome.
Yes, Your Honor. However, it's still present, and the policy behind the court's holding in that was that placing the burden completely on my client or people in the same position as my client is going to promote the illicit trafficking in stolen artwork. It allows for petitioners, people in petitioners' positions, or even art thieves themselves to go into hiding and then assert a defense after a certain amount of time has passed and just state that the witnesses have passed away. As Alexander Amigovich's article, The Successful Use of Latches, states, there are tens of thousands of pieces of artwork still missing. And to allow a simple passage of time and a passage of witnesses to proclaim prejudice bars these claimants from ever bringing their rightful ownership to trial.
But under your argument, they could bring it forever and ever because there's essentially no statute of limitations the way the statute of limitations law is done, correct?
Well, no, Your Honor, there still needs to be the prejudice that's shown. If the defendant is able to show prejudice, then the defense of laches is applied.
So the court that sits in this building was established about 120 years ago. Under your theory, when all these portraits refer to people who have been dead for a century, your client's great-granddaughter can bring the same suit.
Your Honor, I see my time has expired. May I briefly answer? Yes, Your Honor, there is some point where courts have recognized that too much time has passed. And for example, 200 years is seen as too much time. However, there still needs to be a prejudice element in that when it's only 68 years. Thank you, Your Honor.
May it please the court. 2 points on rebuttal, Your Honors. First, the respondents improperly rely upon Magnus. The court in Magnus allowed a suit for damages involving a default judgment. However, whenever the claimants in that case tried to enforce the judgment in the Southern District of Alabama, the court denied that claim because it was against the plain language of the Immunity from Seizure Act. And second, Your Honor, autocephalus, the facts hinged upon the bad faith exerted by the person who had received the object. However, that isn't the case here. Now, Your Honors, prejudice has been successfully asserted in this case, which is a fact issue, which properly, is enough to be summary judgment. So therefore,
Counsel is correct when he says that's your burden.
yes, Your Honor, to prove laches is our burden. And we have brought this court a genuine issue of material fact to defeat summary judgment. And that is why this court should reverse the 12th Circuit's ruling and render judgment for the museum.
Case will be taken under advisement. Court will go into recess momentarily.